I, like a couple of the other speakers, want to pick up really on the problem that is facing patent law. I speak as a lawyer, so I do apologise for presenting, for talking in some very legal terms. So I'm sure if there's anything that you don't understand, you can challenge me after, talk about it afterwards. But in terms of this issue of the distinction between invention as opposed to a discovery is something that is really problematic in patent law at the moment. And I would just, I guess I could summarise my talk really by saying I would be with Graham in arguing that patent law jurisprudence is so difficult to apply to molecular biology, as we have seen in a whole raft of cases across the European Union, as well as in America and other jurisdictions, Canada and so on, where they're really struggling with this, and they're coming up with decisions that are bad, decisions that just really don't add up, they don't make sense. So the question for us as lawyers and kind of policymakers is whether patent law really does deserve to be seen as a lex specialis, whether it should be, it should have its own set of rules, because the law as thus developed just does not sit with and deal with these issues of biotechnology, and particularly the kind of the new emerging issues, as well as the old issue of, do we patent isolated DNA? And if we do, on what grounds do we justify this? How do we say that an isolated DNA containing a particular gene sequence that codes for a particular protein that may have a particular therapeutic effect is actually patentable? The criteria for patentability in the EU and in the US are different. They are different, but we don't have a substantive international patent law at the moment, although this is in process of being put together as a result of WIPO, the World Intellectual Property Organisation, is working on a substantive patent law treaty. Now, I'm just going to, how do I move this on? I just need to, thank you. Okay, so I just want to, having sort of said that introduction, there are differences between sort of substantive patentability, but broadly speaking, there are a lot of similarities as well. So, as between America and the EU, we require that the materials that you are seeking to obtain a patent over is novel, is inventive, and has industrial application. But for that, it has to be subject matter that is patentable in the first place. It can't be stuff that is aesthetic, or it is a kind of activity of the brain, an abstract thought or an abstract process. Okay, it has to be. Patent law is all about protecting technical contribution to the state of the arts. So, in that sense, I come back to this question, is isolated DNA just another chemical compound? Now, in America, American legislation also requires, under Section 101, that subject matter has to be patent eligible. Before you then go on and apply the substantive criteria of novelty and usefulness and utility and so on and so forth. Now, this case, Amgen and Chugai from 1991 is a decision that actually was concerned with erythropoietin. It was the patentability of an isolated gene sequence that coded for EPO, which is very useful in a medical context. Now, this case said as long ago as 1991 that you can have a patent over the isolated gene sequence so long as it is isolated, and we've heard some of the arguments from Robert, about the problem with isolation, and it also has to be purified. Okay, so it's the two things that were required by the court in that case. There has to be isolation, there has to be purification. Now, the problem with Myriad and AMP, certainly in first instance in the district court in America, was that the challenge against the patentability of isolated DNA succeeded on the very basis that we allow patentability in the European Union under the Biotech Directive. Okay, so the fact that this exists, this kind of phenomenon existed, this distinction between US and EU law was not great, and as we know, the case then went on appeal up to the Supreme Court. Now, the sequencing of the genome that was completed sort of in the late 1990s in two places in America under the leadership of Craig Venter, but also the Wellcome Trust in Cambridge here, and the leadership of Sir John Stolston, who heads up the research group that I'm attached to at Manchester, well, one of the research groups that I'm involved in. And they say that, even now, in 2013, yes, it was a phenomenal feat to sequence the human genome, but that the unknowns are still abounding. There's just because we know the sequence of the genome doesn't mean to say that we understand everything about it. Of course not. I'm not a biologist, but I did work in molecular biology for a couple of years. I wouldn't class myself as a biologist. The problems with gene-gene interaction, gene-environment interaction, these are protracted issues for the science that they need to grapple with, which we have then got to apply the law to in order to arrive at defensible decisions with regard to patenting new substances involving DNA. Now, in AMP, then, the focus, as we know, they've said isolated DNA is not patentable. As Robert has highlighted, it was this distinction that the Supreme Court drew between genetic and complementary DNA. Sorry, not genetic, genomic. So stuff that is straight from a blood sample that is extracted in the lab is not patentable. So complementary DNA is the result of a PCR procedure. How can that be patented? What's the difference? How can you understand the difference? Well, the Supreme Court said, well, the difference is that they've taken out the junk DNA, the stuff that doesn't actually code for anything. So the PCR version, this complementary DNA, doesn't contain those things. And therefore, that doesn't exist in nature. So there was a shift from the first instance decision of Judge Sweet, who focused on the fact that Myriad were patenting DNA, and that it was the kind of the genetic, natural genetic process that was the thing that was of value. It was the alchemy of DNA that they were exploiting. This was not something that they had invented. So Judge Sweet then considered that the issue that was before him, which concerned methods and also products that are based on DNA or consist of DNA, are not patent eligible because of the function that they have is not something that's been created in sort of by man. It's not a man-made thing. It's something that is natural. And a law of nature, a product of nature, under American jurisprudence, is not patentable. So in the Supreme Court, they kind of stepped away a little bit. From my interpretation, my reasoning of that is that they're not so focused on this issue of function. Now, function is something that is very important under EU law. In order to patent an isolated gene sequence, you have to specify the function of the gene. Now, in the Supreme Court, they've kind of shifted from, well, the function is a problem, the function is the law of nature, to, well, do you know what? It's the location and the order of the nucleotides. It's whether the actual molecular structure, the genetic structure, has been altered. If it has, as we consider it to be in complementary DNA, then that's okay. But if it hasn't, if you're just extracting it from somebody, you've just isolated it, then that is not patentable. So I think the case has to, the decision in my view has to be applauded. I think it is a good decision, but I just would have liked to have seen more of the focus really on kind of sweet reasoning with respect to the actual function being natural and at the basis of that decision of the Supreme Court. Okay, so what are the wider effects of this litigation then? The first one, really, if you're isolating gene sequences, the main kind of commercial field is going to be those who are involved in personalised medicine. So those that are genetically screening somebody to work out what their response is going to be to medicines. Now, the problem is that sort of in terms of biology, a gene has to be well documented as being functionally relevant in terms of qualifying as something that is worth researching, something that is worth pursuing and developing perhaps a test on the basis of that gene. But of course the problem in patent law is that there is this very strict requirement for novelty. So Recubing is a case from 2009 to the Court of Appeal of the Federal Circuit. They looked at an isolated gene sequence which they held was kind of unpatently obvious. So these other criteria for gene patenting, novelty, inventive, secondary industrial application, then are kicking in, but the Myriad decision is sort of having effects on how those are being interpreted, and I'm just aware of the time, I'm being prompted about time. But just briefly to say that Myriad leaves open the question as to whether purified DNA, does that fall under the Supreme Court analysis? Does that fall under an invention or a discovery, where one is the law of nature and not patentable and the other one is patentable? Purified DNA, okay? HGS and Eli Lilly, this is a decision from the Supreme Court in the UK, which came up with a whole three strata of principles that are applicable to biological material, and particularly genetic material that forms the basis of an invention. And the coherency of that decision is just ridiculous, actually. It is such a poor decision, it's a terrible decision. Really going back to the point that I started with at the beginning, echoing Graham's view that perhaps patent law should be re-legislated, that it is actually a lex specialis.